Stand by.
Okay.
Okay, we're on.
Good morning. I'm Elaine Chapnick, president of the Larchmont Mamaroneck Local Summit, welcoming you to our February program on this snowy morning. Though it's always better in person, I want to thank our co-host LMC Media for enabling us to meet this way on Zoom so we don't have to deal with the storm outside as we hear about our courts. So I'm going to now turn this over to today's chair, Jeff Megan, who will introduce today's program. But before I do that, I do want to remind you that after the speakers have finished, we will have an opportunity for a Q&A. You can push the little icon that gives you a hand raise, and someone will call on you for your question, or you can put your question in the chat, and we will have someone monitoring that and call on you that way. So now, Jeff, you can introduce today's program.
Thank you, Elaine. We are blessed this morning to have a program on our local courts. Most of you might have gone there for a parking ticket, but that's about it. Hopefully not a speeding ticket. But a lot more goes on in our local courts. And we are fortunate today to have a program run by our board member, Judge Daniel Gallagher, who is a judge in the Justice Court of the Village of Mamaroneck. As you know, we have 3 courts in our tri-community area, the Village of Larchmont, the Town of Mamaroneck, and the Village of Mamaroneck. And so we have not only Judge Gallagher, who will take over from me in a minute, but we have Judge Ronald Meister of the Town of Mamaroneck Court, and we have a youth officer, Detective Frank Maresca from the Village of Mamaroneck. And I can say that we are fortunate also to have such a well-rounded, well-educated judges and detectives and so on in the village and in our tri-community area. Judge Gallagher, for example, is a graduate of Bucknell University and Fordham Law School, where he was on the Fordham Law Review. He has practiced law as a partner in a New York City firm and as a senior general counsel to several companies. He is an active member and a former president of the Westchester County Magistrates Association. Judge Gallagher has served as Mamaroneck Village Judge for 16 years. Judge Ronald Meister is a graduate of Yale College and Yale Law School. I was watching Suits and all those Harvard people, so it's nice to have some Yaleys on. Thank you, Judge Meister. He was an editor of the Yale Law Journal. He is a U.S. Navy veteran, having served on active duty for 4 years as a trial counsel and military judge in the Judge Advocate General's Corps. He is a senior counsel to a law firm in New York City and has been a Mamaroneck Town Justice since 2012. Like Judge Gallagher, he is a former president of the Westchester County Magistrates Association. And I might add that all of the judges in our tri-community area and most judges in the justice courts, this is a side job. It's not their main occupation. And so they're in some ways, they're volunteer for our community. Detective Frank Maresca, many of you will recognize him. Detective Maresca is a graduate of Pace University with a degree in criminal justice. And while at Pace, he was a board member of the Pace Criminal Justice Society. And in addition, he interned with the Westchester County Police Department as a park ranger at Playland, which was his first introduction to dealing with youth. He began his career in the NYPD before transferring to Mamaroneck, where he was born and raised. While an officer with the Mamaroneck Police Department, he has served in several different capacities. He was instrumental in starting the first K-9 unit in the Village of Mamaroneck and also serves on the board of the Mamaroneck PBA. He is currently a youth and domestic violence detective. Frank is a member of the State of New York Youth Officers Association and a board member of the Westchester County Youth Officers Association. So it is with gratitude that I turn this over to Judge Gallagher, and we will proceed. Dan, take over.
Thank you, Jeff, for your introduction.
And thank you to the Summit Board for inviting the panelists today, and for LMC TV and media for jumping in to provide us with this alternative way to proceed. Now, I'm looking out the window right now and I'm enjoying with childlike wonder, the snow coming down. But this morning I was thinking about a passage from David McCulloch's spectacularly excellent biography of John Adams. And in the wake of the battles of Lexington, Concord, and Bunker Hill, then Delegate Adams had been summoned to a session of the Continental Congress for a meeting in Philadelphia. And according to his biographer, Adams, in the dead of winter in January 1776, traveled by horseback down the Post Road west across Massachusetts, then passing through New Haven and Stamford and Greenwich on through New York City on his 400-mile journey to Philadelphia and onward to history. He probably also passed through Mamaroneck on his way back then, perhaps through a similar snowstorm. So I am happy to say that we do not have to go out today to into the snow, whether by horseback or by motor vehicle. And I'm pleased that we can still continue with our meeting today despite the weather. But I digress. I'm going to have some comments today. And when I focus specifically on the Mamaroneck Village Court, much of what I say has equal application to our neighboring courts of the town of Mamaroneck and to the village of Larchmont. So for your information, there are approximately 1,200 town and village courts in the state of New York, and 34 of them are centered here in the county of Westchester. All Westchester town and village judges are lawyers, although that's not a legal requirement. That is not always the case, specifically upstate. The village of Mamaroneck Court has served its community for over 100 years. Our court typically ranks among the 5 busiest town and village courts in Westchester and among the top 35 busiest courts, local courts in the state, based on rankings provided by the New York State Controller's Office. So like the town of Mamaroneck and the village of Larchmont courts, the village of Mamaroneck Court operates as an independent branch of the local government. Judge Derrico, Christy Derrico, and I share responsibilities for management of the village court, including supervision of our 4 full-time professional clerks, Bonnie, Alita, Marcia, and Akeem. And while we rely on the financial support provided by the village, we're essentially self-funded through revenues generated through the court's operations. And I'll also note that the purchase of virtually all of our computers and other office equipment has been funded through state grant applications submitted by the judges and staff. So we try to be an efficient, economical institution of the village of Mamaroneck. So what do our local courts do? Well, there's a lot to cover in a short time. And once I'm concluded, Judge Meister will pick up where I leave off. But our courts include criminal case jurisdiction, landlord-tenant matters, code violation cases, small claims cases, traffic and parking tickets. And keep in mind, if you get that parking ticket, it's a police officer that issues it to you. The judges don't do that. We adjudicate the tickets, we don't issue them. So we'll leave that for Detective Maresca to deal with later on. So in the case of our court, all criminal matters, whether felonies, misdemeanors, or violations that occur in the village of Mamaroneck, come before our village court. So virtually all criminal matters find their way into our court. How they proceed after they're in our court depends on whether they're felonies, misdemeanors, or violations. And for those that are not familiar with it, generally speaking, the definition of a misdemeanor versus a felony depends on the length of the potential sentence, with felonies being possibly a sentence of over a year and misdemeanors with a possible jail sentence of up to 1 year. So you should also know that our village courts, our town and village courts, are not the only courts in the in Westchester County, and Judge Meister will touch on the other higher level and specialized courts in Westchester in his remarks. The village court conducts its criminal court sessions on Thursdays and other matters on Tuesdays. We also conduct trials and occasionally a jury trial in our courtroom. We have a jury trial. We have 6 jurors and usually 1 or 2 alternates that see us through the trial proceedings. So also, your local judges are on call 24/7 for arraignments of defendants arrested after hours and for search and arrest warrants. So for example, last weekend, I was called into court at 11:30 p.m. for a defendant charged with criminal contempt for violating an order of protection. That defendant had failed to appear repeatedly in 2023, and a bench warrant had been issued by me for his return to court. At this arraignment, the defendant was assigned an attorney to represent him. Bail was imposed, and his next court date was then set. So for your information, in all criminal cases, defendants have a right to counsel in all stages of proceedings. The judges appoint counsel to represent criminal defendants from a list of we call them the 18B list of certified defense attorneys, and they are appointed to defendants who demonstrate they are unable to afford their own attorney. And for your information, assigned counsel fees are paid by Westchester County and not by the local municipalities. Criminal cases are a large component of our court's responsibilities, but I'd like to highlight a couple of areas of court functions that may not or may have more relevance to our audience today. So, for example, we regularly handle small claims cases. These are cases with a limit of a $3,000 recovery. They are civil cases with a nominal payment of a fee. You can commence a civil action. It's an easy filing. You come in, you file a short 1-page description of your claim, and the court mails it to the defendant. No lawyer is required, and there are a variety of situations where people come in and commence small claims actions against defendants that have some kind of nexus, whether business or they live in the village, but they have to have a nexus to the community. So a couple of examples I've seen are claims where a landlord didn't refund a security deposit at the end of a term of a lease. A contractor did not do the work that was agreed to or paid for. A client didn't pay for professional services that were provided. But we encourage before the start of a small claims case for the parties to get together and see if they can work out their problems between themselves without the involvement of the court. And frequently, this is the first time people have come face to face, and understanding that they can't predict how a trial will go. Frequently, they work things out and agree to a settlement before we actually go to a court trial proceeding. The other area of interest, I think, and a big part of what we do is landlord-tenant summary proceedings. These are essentially eviction proceedings that are brought by landlords claiming usually either a non-payment of rent or a holdover beyond the term of stated in a lease. These are cases typically where the landlords come represented by counsel, and more typically, or typically the tenants are pro se, they don't have their own attorneys. Unlike criminal situations, criminal cases, the court does not have the ability to assign counsel to indigent tenants, and they do have some recourse to the not-for-profit legal services of the Hudson Valley, but in my experience, the demand for their services exceeds the supply, and so frequently we have litigants that are unrepresented in these kinds of landlord-tenant proceedings that sometimes work out with a payment of the arrears and the dismissal of the case on that basis. And then sometimes they work out with a deal where the tenant is given time to pay over time. to the arrears that are due, and then sometimes they unfortunately result in an eviction. Then there are code violation, a variety of code violations come before the court. For example, homeowners or businesses that do construction without permits. That's on the more serious side because there are dangerous circumstances that arise with work being done without permits, particularly electrical work. And then the other extreme, we have tickets being handed out for failing to shovel sidewalks after a snowstorm. So I wouldn't be surprised to see a few of those turning up in our court in the weeks to come. So we are a busy court. Just statistically, to give you some context, our court handled approximately 7,400 cases last year, not including parking tickets, landlord-tenant cases, and village code violations. And our court processed about 15,000 parking tickets. So we are pretty busy. Just individual breakdowns, choosing a couple of categories. We had 104 DWI charges that were filed before our court last year. We had 1,051 speeding citations. So we are busy. Our staff and the judges are proud of what we do. And I'm looking forward to any questions that people may have down the road about what it is that the judges in the village and town courts do. And so with that, I'll turn it over to Judge Meister. And Judge, you take over.
Thanks, Dan. I too read of John Adams' trip, which must have taken him through Mamaroneck. I don't know what the speed limit for horses was in the 1700s, but perhaps we can go back to the archives and see if our constables at the time issued him any citations for galloping through the town. Like the village of Mamaroneck, we have the same jurisdiction. Our court is held weekly, but the judges don't just show up on the nights that court is in session. There's a lot more that's parts of the job. There's research, there's opinion writing. We get presented with search warrants. We have a lot of committee work for magistrates associations and for state organizations. I myself am on the State Advisory Committee for Judicial Ethics, which gives advice to judges as to what's proper. Probably the most common non-regular day activity is the off-hour arraignments that Judge Gallagher told you about. We are on call 24/7, and that's unlike any other court. And particularly, it's unlike city courts. So if you have a matter, there's an arrest, a late night arrest in Mount Vernon, you're in jail overnight. And indeed, there can be very unfortunate consequences of that. There was a very unfortunate case in Mount Vernon a few years ago where a woman was arrested, and by the time her processing was done, the city judge Mount Vernon had gone home. That was a Saturday afternoon. There was no court till Monday. She had a medical condition which was undiagnosed. She was placed in the lockup, and she died. That sort of thing would never happen in a town and village court. We would get the call from the police. The judge would arrange for counsel. The judge would get input from the district attorney's office, and the arraignment would proceed at whatever time it would be. We try very, very hard not to have anyone unnecessarily overnight in lockup. Like the village, we have full-time staff of court clerks. We do not have law clerks. We do not have law school educated clerks, which means that we do our own research, but we also have access to a resource center that was established by the state, which is essentially a law clerk pool for us in Albany that's available theoretically 24 hours a day. And we can call up and describe our problems and get the benefit of the input of staff whose job it is to give us that information. We have our own assistant district attorney assigned to our court. We have a group of more or less regular defense counsel. I would say about a third of the cases we have are for defendants who retain counsel out of their own funds, and the other two-thirds get appointed counsel from a qualified panel of defense counsel who we see frequently. One of the problems that we have, or one thing that could be improved, is that the district attorney's office in Westchester County is vastly understaffed. They don't have enough qualified lawyers to serve as assistant district attorneys. And more often recently, we've actually been seeing law students, law school graduates, show up as our ADAs, pending their admission to the bar. That's not ideal. They're supposed to get supervision from more experienced district attorney, assistant district attorneys. From what we see, we're not sure that all of that supervision is really adequate. We are extremely proud of the performance of our courts during the pandemic. Our courts never closed. We ran full speed with our regular calendars, the only exception being the suspension of some landlord-tenant cases by state law, which suspended evictions and those proceedings for some time. We were ready to do it. In fact, we were complaining with our administrative judge that we can do these cases, but the state legislature decided that there would be a moratorium on some of them. So I thought, Judge Gallagher, having given you the general outline of our cases, I thought I would focus a little more specifically on some of the more common matters that we see and the issues that arise. First of those is driving while intoxicated. There has been an epidemic of DWI in Westchester County, which was made worse during the pandemic. And I would say that half of our criminal calendar is now filled with DWI cases. I've had nights where I've had nothing but DWIs on my criminal calendar. I know that in White Plains City Court, where Judge Gallagher and I occasionally sit as fill-in for judges when they need a little help, they have a separate calendar just for DWI cases. There are so many of them. And we can talk perhaps later, if anyone's interested, why this is, why it was fueled by the pandemic, but it's a great reality. And an interesting aspect of the treatment of DWI cases is, somewhat surprisingly, an effort by the Westchester County District Attorney's Office to decriminalize drunk driving and to offer resolutions of cases that do not require pleas, even to misdemeanors, certainly do not involve jail sentences, but focus more on treatment and prevention. And one of the tools that's available to us is the installation of an ignition interlock device, which is a great development in treatment in this area, where the driver cannot start the ignition without first blowing into equipment which will tell if they are intoxicated. But it is somewhat odd that the district attorney is not insisting in many cases on pleas to even a misdemeanor. The general treatment of DWIs may be a surprise to people. How many points on your license do you get for a conviction for driving while intoxicated, which makes you a danger to yourself, to your passengers, and to those around you? How many points on your license? 0. How many points on your license for using a cell phone while your car is in motion? 5. That's the wisdom of the Department of Motor Vehicles and the New York State authorities. It's not up to the judge to put points on your license. Another type of case that we see frequently are domestic violence cases. And the issues that confront us at the very outset of those cases are requests for orders of protection. It is commonplace for the district attorney's office to seek an order of protection against the defendant at a stage in the case where we know virtually nothing about it. We see a charge and we see the potential for risk, and we are asked to enter orders of protection that would include, in an appropriate case, staying away from the protected party, which may mean not going home, not harassing the protected party, and not communicating with the protected party. This puts the court in a difficult position because we don't have the kinds of resources that, say, Supreme Court has, that family court has. We have only allegations. And those allegations may, before any proof is introduced, lead to someone being kicked out of their own home for the duration of the case. Obviously, that is a matter that is reviewed as the case goes along. And the courts have recently recognized that where a property interest of the defendant is involved, by that meaning their ownership of the apartment or their home, then the defendant is entitled to a hearing as to whether it's appropriate to have a stay away in that case. But no one knows what that hearing is supposed to consist of. And while the defense counsel can ask for a hearing, they rarely do. I think because they know that there's really nothing they can say at that point. Judge, I live there. These allegations are all false. They're entitled to a presumption of innocence. I have no other place to go. And yet the assistant district attorney is asking that I be put out of my home. Those are some of the things that are most difficult for us to do. Let me talk then finally, especially about landlord-tenant cases. Judge Gallagher has given you the outline of those. I would say that the single biggest structural problem for local courts is the lack of counsel for tenants in landlord-tenant cases. A defendant charged with the most minor misdemeanor, say a petty larceny, shoplifting, is entitled constitutionally and statutorily to appointed counsel at every stage of the proceeding. A tenant who is facing the loss of their home is not. What we say, it's a little harsh to say it, but the landlords show up in court with their lawyers, and the tenants show up in court with their babies. And while that may be sympathetic, the babies rarely offer cogent legal advice. Now, there is an initiative in Westchester County to provide, through legal services corporations, principally the legal services of the Hudson Valley, counsel to be appointed free of charge for tenants. That's being worked through. It hasn't happened yet. That would be a great boon to tenants, and it would be a great boon to the courts, because we operate under an adversary system where each side presents its arguments, and the judge, without having to make up or discern all the issues in a case, is aided by knowing what each side contends. So we look forward to the implementation of that program, which I think will be a great help to tenants and to the court. I think with that, I will add one thing. Jeff, at the outset, said that he's happy not to be dealing further with graduates of Harvard Law School. My co-judge, Jean Marie Brescia, is a graduate of Harvard Law School, and actually has some rare occasions to make use of the education that she got at that institution. So I think we complement each other on the bench for that.
Ron, before you move on, I think one other big topic I'd like to make people aware of is the recent bail reform that the legislature passed a few years ago. And without going into a whole lot of detail, basically before bail reform was legislated and enacted, judges had pretty wide discretion to set bail in criminal cases. And I think there's certainly arguments on both sides as to whether the legislation went too far or didn't go far enough. But the reality is that the number of cases that we can actually set bail on has been severely reduced. And so I'll point out a situation where a person might be charged with a misdemeanor crime of assault on somebody that is a stranger to them. That would not be bail eligible, but looking at the person's rap sheet, it shows a history of convictions for violent crime and failures to appear in court. And in those circumstances, when the judges have a pretty good sense that the person's not going to be coming back to court if released, our hands are tied and we're not able to set bail. So it is a reality that we deal with regularly, but it is certainly one of the major points of legislation that have passed in, that impact our local courts in recent years. But I just thought I'd throw that in as well. I don't know if you have anything to add to that, Ron.
Briefly, the bail standards in New York State differ from virtually every other jurisdiction in the United States. The principal purpose of bail is to assure the return of the defendant to court. An additional purpose of bail in virtually every other jurisdiction is to protect the public safety. New York is the only state in which the potential of further crimes by a defendant is basically not a factor in the setting of bail. We may consider the seriousness of the offense, and modifications to the bail law in recent years have granted us additional power to consider that. But much of the discretion of judges has been taken away. And that is a source of dissatisfaction among many of the judges who are confronted with cases, as Judge Gallagher said, where you have a long history of failure to appear, you have a history of prior convictions, and yet there are large categories of crimes for which we may not set bail. We can impose certain restrictions on liberty, which are really patchwork. We may require our defendant to call in to pretrial services once a week. We may take away their passports, but we can't set bail in large categories of cases. And the difference, bail reform came about largely because of abuses at Rikers Island in New York City, where there were long, long delays between arrest and resolution of cases, and people languished in very bad conditions in Rikers Island. That's not the case here, where we get to our cases far more promptly. And the purpose of bail in many of our cases before bail reform was to be sure that the defendant could post the bail and that it would be held over their head, and they would know that if they failed to show, they would be at the risk of forfeiting bail. So we are unable to do certain things that we were able to do before. There is one other category of discussion which I know our host had asked us to speak about, which I'll mention very, very briefly to give the detective his time. And that is that there are specialized courts in Westchester for certain kinds of offenses. There's a veterans court, there's an integrated domestic violence court, there's a drug court, there's a mental wellness court. Those are diversion programs that we are empowered in certain cases to refer cases to. That happens, in my experience, extremely rarely from our courts because they generally require the consent of the parties, and the parties rarely consent. Whether they feel they'll do better in our local court, whether they feel it would slow things down to be in a specialized court or not, we're not sure. So while there is a theoretical possibility of referral to those specialized courts, which have far better resources than we do, we can't treat people for mental illness. We can't treat We can't review the veterans' records of defendants. So it would be beneficial if more cases were resolved there, but very few of them are. All right. Thank you. We'll be answering questions afterwards. Detective, you're up.
All right. Thank you. Good morning. Can you hear me?
Can hear you.
All right. So, I mean, you guys covered a lot already. I'd just like to point out that during COVID, myself and Judge Gallagher, we had the first ever virtual arraignment on a domestic case, and an order of protection was issued without the judge actually having to be in the courtroom. So that did work out in one instance. So
Seems like a century ago.
yes, yeah. Let's hope we don't have to deal with that again. So you guys covered a lot already so far. Basically, I'm just going to speak about how the juveniles are implemented into the court system. So basically, again, we have the three law categories, violations being the lowest, misdemeanors, and felonies. So for juveniles, anyone from 7 to 11 years old, we cannot charge them with a crime unless the severity of the crime is very high, which basically is almost like an attempted homicide. It's very, very, very rare. Anyone from 12 to 17 is considered a juvenile delinquent, and they would go to family court and see a probation intake officer to handle the case. They would not get fingerprinted, and they would not see a local criminal court judge. And then recently they implemented a AO court, which is an adolescent offender court for 16 and 17-year-olds who commit felonies. So it was very confusing. We have a list of where each charge and the age would actually go to which court. So we have White Plains Family Court is where the Village of Mamaroneck, Town of Mamaroneck, and Larchmont would send their juveniles. New Rochelle has their own family court, and Mount Vernon has their own family court. But White Plains is pretty much the main hub for a lot of the towns and villages. I believe Pelham might go to New Rochelle or White Plains, and a couple other towns and villages might use those city courts, but the majority of the towns and villages will go to White Plains Family Court. Basically, my job as a youth officer is not to arrest juveniles, but to try to keep them out of trouble. We know juveniles make bad decisions. We try to work together with the school, the community, and the parents of both parties, whether there's a victim. The victim could be a store owner. The victim could be another student, another juvenile, an adult. We really try to mediate and meet together and try to really handle the situation before an arrest is made. And again, an arrest really entails an appearance ticket to whichever court that the charge and the age fits. We work together with the Town of Mamaroneck and the Village of Larchmont. My partner, Detective Chris Yeager, we have 2 youth officers and domestic violence officers here in the village. The Town of Mamaroneck has Detective LaRosa, and right now Larchmont has Detective Lent, and they're training another officer to help out. We all do share the same school district. The Mamaroneck School District is covered by all 3 municipalities. We also, the Village of Mamaroneck also covers Rhinebeck schools. And we also have a French American school, and we have the Westchester Hebrew School. So for a small village like Mamaroneck, we are pretty busy, and we actually have 4 high schools right here in our small village. So again, it is very confusing, but pretty much we try to act as liaisons. So for example, two kids might get in a fight in school. It can be handled several different ways. If the parents are content on how the school is handling it, they might bring us in. So you'll have the police department, the school, and both sets of families and kids, and we try to nip it in the bud right then and there. We have a meeting, there's no charges, we'll document a report that just says, we all met for this incident and the school is handling it and both sets of parents are content on how it's handled. Same thing, for instance, Mamaroneck Avenue, it's happened before. Kids are horsing around, somebody gets pushed into a storefront window, the window breaks. So that can be a little tricky because any damage to property over $250 raises it from a misdemeanor to a felony. So that, that can become a problem. So again, if we meet with the store owner, we have a discussion, if the parents and all the kids come together and they're willing to pitch in and possibly pay for the damage in lieu of charges, that's great if we can work it out. Sometimes they don't want that type of restitution, then we might have to issue an appearance ticket for them to be content. But we do really try to work it out. And most of the cases we handle, we're able to, mediate it. And I believe the judge mentioned it before, where some of the courts is diversion court. This is basically the same idea. We try to divert it ourselves, which we call handled in the department, where we're able to handle it with the complainants and victims, which is great. Other times we might have to issue the appearance ticket. And most of the time, as long as there is, support from the family, even if we have to issue an appearance ticket, which is the same as an arrest, when the support is there, they divert it as well. There's a youth court that I've actually sat in on a Zoom meeting where, there was a judge that was a juvenile, the attorneys, the prosecutor, the jury, and basically they came up with community service. This one happened to be where a juvenile got into a fight, maybe had some anger issues, and they went for a little therapy, little anger management course, did some community service, and that's it. They very rarely ever get handcuffed, or we're not allowed to put them in the jail with any adults. And basically, it's a whole different set of rules. I know it can be confusing, but if anybody has any questions, definitely be able to answer them.
So Frank, my sense is that to get the best results in dealing with young adults, it involves real involvement of parents and a willingness to deal sensibly with the alleged charges. What happens if you don't have parents that are involved? Let's say you have a child whose parents just are not being cooperative. It depends partly on the seriousness of the alleged crime, but where do kids go from there?
So, for instance, a domestic violence case involving a juvenile where an appearance ticket to the juvenile and their parent really wouldn't work, because we have to send that juvenile now home with the parent where the initial issue or incident occurred. And if they can't control that child, so at the in Valhalla, next to the hospital and the jail, there is a facility called Woodfield Cottage. And that is a secure juvenile facility where, if need be, we could send them there. There's also a facility called the Sanctuary, which is basically a shelter for juveniles who can't get along with their parents, that is a voluntary place where a juvenile could go if they're having problems with the child, and they will get them transportation back and forth to school. They have counselors on scene, but it's a voluntary place, and it's not really long term. It's very short term until they could either get to family court and really figure out how they're going to help this family work it out, because it is very difficult, because we do not have many facilities to house juveniles. And like Judge said earlier, you know, certain cases do require arraignments, even for juveniles. And if we can't get a judge in to arraign them, we really have to sit on them overnight, and we really don't have the facility to do that. They would either stay in my office. Sometimes we've had multiple juveniles, and we basically stayed in the courtroom with them. We called their parents and just waited there until we can figure out how the next, you know, point of action is to proceed. So that is very difficult. Luckily around here, most of the time we do have, you know, the parent support, and we're able to work it out. I don't know, Dan, if you were involved with the kids from Missouri at all that came here with, they took their grandmother's car and drove all the way from Missouri and ended up in Mamaroneck. So it happens. We had to wait for their parents to come and basically pick them up. So it's it could be definitely it's a different ball game than the adults in the criminal court system.
Okay, well, thank you, Frank, for your presentation. I think we're at the time when it makes sense to open up for questions and answers, and I think Peggy, you're going to be hosting that.
George Latimer has a raised hand.
Hello, George. You have, okay.
Yeah. Am I unmuted?
You are unmuted.
Okay, very good. Great presentation, gang. Was interested for both Judge Gallagher and Judge Meister if they have had much need for guardian ad litem program for some of the people that come before the court. The county has been involved with the 9th Judicial District, and in some of the other courts, we've had local judges say that appointment of guardian ad litem and then the indemnification of those individuals are important. And you can explain what the program is probably better than I can for everybody else listening. I'm just curious if those cases have come before your court.
So I'll go first. I haven't had a situation in a couple of years that warranted a guardian ad litem. That is a situation where a person is deemed perhaps incompetent to represent themselves. The last time it came up, and it was before this program was in place, I had a landlord-tenant situation where an elderly woman who was also, clearly mentally challenged, was probably a hoarder. The proceeding went on for months and months and months, where we tried to get a family member who lived in California to participate and act on behalf of the tenant that was facing eviction. But to answer your question, I have not recently had it, but I am very conscious of it when I have people come into court that may be appropriate for that option. And Ron, you?
Not per se. There is a proceeding under the criminal procedure law for incompetent defendants in criminal cases that can lead to examination and potentially diversion from the criminal process. But in that case, the defendants are represented by appointed counsel, or indeed, if they wish, by retained counsel. So we haven't had resort to the guardian ad litem process in our court.
But I'm happy that it's there, George, for when it does occur.
Great. Thank you.
Marlene Colbert has her hand up.
I'll ask my usual environmental question.
Morning, Maureen.
Hi, how are you, Peggy?
I'm fine.
I'll ask my usual question, which is, we in Larchmont have worked very closely with Justices Beaver and Bernstein because we're very concerned about the judges following what's procedure for environmental issues. And I'd like to know what's come before your court in terms of gas-powered leaf blowers and whether you've actually issued those tickets, because otherwise people just keep doing the same thing over and over. Thank you.
Ron, go ahead.
First of all, hi, Marlene.
Hi
We
there,
don't
how
issue
are
the
you?
tickets. There are code enforcement officers whose job it is to enforce them. We usually see in our court a blitz of tickets at the appropriate time of year when people are using gas-powered leaf blowers. The town has increased the penalties for use of gas-powered leaf blowers at inappropriate times, and the fines are higher, and they are negotiated by our town prosecutor, and which usually results in a consented fine.
Yeah, so the same occurs in our court when we get the leaf blower violations. As Ron points out, we don't issue the tickets.
Right, we know that.
We adjudicate them, and the defendant usually comes before the court, is arraigned, ask if they want counsel to represent them. Since it's a violation, not a crime, they have to bring their own attorneys. But ultimately, there's a discussion between on consent of the defendant, between the prosecutor and the defendant, and a deal is usually worked out. And the deal usually involves the payment of a fine. Now, sometimes the fines are left to us to decide, and it's based upon a range of fines. I think it's up to $250, but the range is 0 to $250, and based upon our understanding of what occurred, whether the person is a repeat offender, I set the fine that I think is fair under the circumstances. But we also usually hear what the prosecutor recommends in terms of what the appropriate fine is.
Are there any other questions out there?
I have a question. I wanted to pursue, Ron, what you had said about the reasons for
Peggy?
DWI. You said you thought there were some reasons that could be, that you would like to speculate on as to why the huge increase in DWI violations were coming up.
Sure, it's more a sociological issue than a legal issue, but my own view is that a major factor during the pandemic was that people who used to do their commuters who used to do their drinking in the city and then work it off on the train are now doing their drinking at home because they're working from home and driving around locally. So the total volume of drunk driving may be about the same, but it's shifted from the city to our jurisdictions. I think there was also a degree of frustration that everybody experienced during the pandemic, which might have led to more drinking. And I think there's just a general unhappiness. There's also, I found in organizations that I belong to, I found an increased, a shockingly increased programming involving alcohol. And the most innocuous social events, even for civic institutions, seem to have a bar. And not all of those involve trained bartenders who are at least supposed to be able to identify when someone has had too much. So you really don't want somebody driving home from church or from a library meeting or a school board meeting. I'm not suggesting the school board has an open bar, but there are social events that seem to me to feature a lot more alcohol than they used to. And I think one reason why we don't treat DWI more harshly than we do is that because the people who make the rules think this could be me. They
Mm,
don't think that of larcenies. They don't think that of assaults. They're not going to say, "Oh, I better not be harshly punishing uh, assaults because maybe I want to beat up my neighbor." But they do think, I take a drink from time to time, and I might not be careful enough, and I don't want to go to jail. I don't want to have a crime on my record. So we better not treat that so harshly.
mm.
Um,
Do we have
I have a,
questions? I'm sorry.
I have just a comment, Chef Megan. We have in our community that Summit covers 3 municipalities, we have 6 judges, and 2 of them are here. I think it would be nice if we named the other 4 judges. So either Ron or Dan, could you give us the names of your 2 other compatriots and the judges in the village of Larchmont?
Dan?
Well, Judge Christy Derrico is my co-judge here in the village of Mamaroneck. And Ron, I think you mentioned your co-judge.
Yeah, I did briefly mention her education. Jean Marie Brescia is my colleague. She's actually been on the court longer than I have. And like Dan and I, has also been president of the Westchester County Bar Association. And even though she's not here, I have to say I couldn't ask for a better colleague. It's so helpful to have a good working relationship. We have to work out our schedules. We have to work out the hiring of our clerks and the other issues that come before us. And it's been a great pleasure to me to be working with Judge Brescia, as it has the judges in the village. We all meet from time to time and talk about issues that are confronting us and how things could be improved. And that's a very fine thing.
We have 2 more hands up, Frank Clemens and then Janet O'Connell.
Well,
Should we,
could you mention
Jeff, should we
the,
finish
2
answering your
judges in the
question?
village?
Jeff, I'm not sure we answered your question about the village of Larchmont judges.
Correct. Would be. Go ahead, Ron.
Jerry Bernstein and Thea Beaver are the judges in the village. They've both been judges there for quite some time.
Thank you.
Go ahead,
Frank Clemens?
Frank, go ahead. Frank, turn on your audio.
Frank, can you unmute, please?
That's it. Frank? Maybe take the next one. Take
We
Janet.
go to Janet O'Connell.
Janet, unmute. Where are you, Janet?
Janet, unfortunately, doesn't have her hand.
Hello? This is Frank Clemens. Can you hear me?
Yes.
Now we can.
Here's my question. How can one commence a small claims breach of contract action in an upstate jurisdiction without traveling to the town?
I don't have the rules for jurisdiction in front of me, but generally speaking, a small claims case has to be filed in the village or town where the defendant has a nexus or a connection, whether it's a residence or a place of business. So don't think I could help you there. Ron, anything to add?
You can contact the clerk in the jurisdiction. Excuse me, I will just mute myself while this call is sorry. You can contact the clerk, which you can probably find online how to do that in that particular county, and ask what procedures they have. And who knows, it's conceivable they might have remote proceedings that they would allow you to pursue.
Well, I was thinking of the initiation of the action filing the paper to commence the action, could that be done remotely? And I guess your answer is ask them.
Yes.
Yeah, I think every court probably has its own procedure in terms of whether they'll accept a fax of a document. I mean, our court, our webpage has I think has the filing form for a small claims case. I don't know offhand, but my guess is that we probably would accept a filing that's appropriately certified by fax. But that's going to be based on the local jurisdiction, but odds are you're going to have to actually appear on the assigned court date if you are actually able to commence a proceeding, by simply mailing in a form.
Thank you.
Mitch, are we able to locate Jen O'Connell?
She does not have her hand up at the moment.
Okay.
I think our time is up, and so I really want to thank our panelists, Ron, Dan, Frank, and Peggy and Jeff for assisting this morning, and certainly LMC for making all this possible. Thank you all for coming. Thank everyone who is in attendance that I can't see for coming to us on this snowy day in this format. And let's hope we see you in person next month on March 12th, when we will be talking about the open spaces in our community and how they're used or might be used. So hope to see you next month. And again, thank you everyone for pulling this together.